Okay, welcome back. Our next panel is Global Incident Response, Managing Incidents Impacting Global Enterprises. And we have another terrific panel. Let me start by introducing Sean Hoar. He is a partner and chair of the cyber team at Constangy, Brooks, Smith & Prophete, based in Portland, Oregon. And Sean previously served as the CHIP, or the Computer Hacking and Intellectual Property Lawyer for the U.S. Attorney's Office in Oregon. Welcome, Sean.
Good morning. Thanks, Bruce.
Our moderator today is James Lloyd. James is a partner at Latham and Watkins. He's based in London. He's an experienced litigator and investigations lawyer who represents clients on cybersecurity, ransomware, and privacy-related matters of all sorts. James, welcome back. Nice to see you.
Nice to see you, Bruce. Thank you.
And finally, very pleased to welcome Jarno Vanto, a partner at King & Spalding. He's in the New York office. And Jarno is in the firm's data, privacy, and security practice. Jarno, great to see you again. Welcome.
Thanks, Bruce. Great to be here.
All right, James, let me turn it over to you.
Thank you very much. Hello, everyone. Thank you so much for joining this panel. As Bruce said, we're going to dissect a critical and evolving facet of our cyber legal landscape today. We've got global incident response, managing incidents impacting global enterprises. So global is the word, twice in fact. So I'm James Lloyd. I've got the privilege to be moderating it with Sean and Jarno today. Over the next 45 minutes or so, we're going to aim not only to explore some of the overarching challenges, but also to delve into some of the nuances that make incident response for global enterprises a continuing challenge and a bit of a puzzle. We're going to touch on the challenges around coordinating the response across the globe, multi-jurisdictional intricacies, the pivotal role of local counsel, some of the complexities surrounding sanctions, and if we have time, we'll look at some regulatory changes and maybe some of the shifting landscape and risk that we've seen in terms of CISO and GC liabilities. But let's dive in with our first set of questions, thinking about coordination in particular. I know, guys, that when we touched base before this was first on our list. And I think, it's something that the three of us always encounter with global clients, the challenge of getting joined up, because ultimately good incident response depends on it. But given these pockets of expertise you inevitably have are scattered globally, especially in the context of group-wide breaches, how do you guys address the coordination challenges arising from diverging priorities across different local markets, different business units, and the like? What do you see? Feel free.
James, one key element is testing. You've got to test your incident response processes before the actual incident occurs. So there's really nothing much more critical than that. It's critical to test the systems, test the coordination with local counsel that you mentioned, test local country teams to make sure that they can coordinate with the headquarters. That's critical.
And as part of that, James, I'd suggest that as in terms of the vendors that you've got, at least your key vendors, probably your key forensics vendors or multiple vendors in an international context, be engaged in a tri-party MSA perhaps outside the crisis stage so that you actually can test with them as well and make sure that they're well suited to respond any time of the day or night. Time zone issues come to play when, in fact, you've got vendors who may not necessarily have that footprint, and you've got clients that may be spread around several different countries as well. And so that coordination ahead of time, getting those contracts in place, but also, like Jarno mentioned, testing it as well. Tabletop exercises, and of course, the virtual international tabletop exercise is going to be your virtual event when it happens.
Yeah, absolutely. It's in terms of testing, presumably the main advantage there is you're ironing out any issues in advance, right? Like fundamentally, if there is that disparate group across the globe and folks have different ideas about how they want to run the response, that's when you run into trouble. Do you guys have perhaps some war stories about what went well or perhaps what went wrong?
Jarno, if you want to go first.
Yeah, so on the technical vendor side, obviously challenges. Some vendors that may be good in the US may not be so good in the European Union or Asia Pacific region. So you may have to look into having several vendors, which makes the challenge of coordinating between those vendors even more cumbersome. So again, just going back to the testing comment, it's critical you make sure that you have those teams coordinating well with one another across the globe.
And I find it in the testing process, to the extent that we've got an IRP in place with specific vendors, and you do a cross-functional tabletop where you don't just have your InfoSec or your IT providers within the organization, but you've got your different business units, your marketing and communications, your risk compliance, your financials, human resources, et cetera. They are going to have different roles to play. Many of them don't recognize they're going to have a role unless they actually do participate in the processing. And the challenge is if you've got similar business units in different jurisdictions as well, sometimes they don't necessarily understand how they can actually coordinate in a data breach related context, because typically their responsibilities are jurisdictionally specific. But when you're talking about a data security incident, they've all got to be working basically completely synchronized in a uniform way throughout the organization. And that's where tabletop exercise and testing that incident response plan is so critical in an international context.
Yeah, absolutely. So everybody's rowing in the same direction. Sorry, Jarno.
No. I said that I agree with that assessment. Absolutely.
Yeah, I've certainly had issues in the past where business units in perhaps away from the center, away from the headquarters, who perhaps are running the incident, consider their part of the business, understandably, to be the key part, and will make their own judgments about regulatory obligations. Perhaps they've got existing relationships with regulators that they want to maintain, and perhaps it can be challenging at times to control that desire, that folks have to share more, and ultimately you end up having to sort of herd cats, if you will, where you have just different folks pulling in different directions. Have you come across that? Do you, aside from assuming that perhaps you haven't had the opportunity to prepare and run through a tabletop, do you have thoughts on what strategy might be appropriate to try and rein that in?
Going back to the making sure that your local teams keep you updated on their developments on the ground in their jurisdictions is critical, because what we've learned in tabletops is that the headquarters only learns during the tabletop that there are, for example, industry specific or sectoral regulations in countries in which they operate that they didn't or were unaware of until the tabletop was carried out. And so you don't want to have surprises like that during an actual incident.
And one of the challenges there, too, is that different jurisdictions, you may have at least perceived reporting requirement differentials. And so you may have somebody in one country who says, well, I've got a great relationship with this regulator, and I know that I need to do this within 24 or 72 hours, where someone else says, well, we don't need to do that. But as soon as one does it in one country and it's related to the same business entity, it's going to start to trigger things in other countries, or at least inquiries. And so we've got that's one of the bigger challenges actually in an actual incident. And so if you can test that out ahead of time and get a feel for what the perceptions are about the reporting requirements to make sure everybody's aligned, then you can coordinate that in an actual incident as well.
Yeah, absolutely. I think it's that perfect world, though, isn't it? Testing is so important, and preparing and practicing. But I think ultimately, I can't tell you how many times we've been parachuted into situations where the practice hasn't happened, or at least hasn't happened as well as it should have,
Right.
And it really does throw up challenges.
Right. And I think another part of that too is communication is so critical. And sometimes we found that someone will actually report without telling the team, because that's how they operate generally as part of running their own business unit in their own jurisdiction, not necessarily recognizing how critically different communication can be, especially with a regulatory or other third party, a regulatory entity or a third party in the data security context. And so sometimes, to the extent that they continue to do that on their own without communicating to the team, it can cause problems with the other team when you find out the next day that somebody's already been notified. And then you've got to start, that a whole nother communications process and it's going to consume resources you didn't expect to be consumed.
Right. And even just the fact that people may be talking about different things. So aligning on what we're talking about when we're talking about incidents, for example, we need to understand what people are concerned at a country level. Some members of country teams may be concerned about criminal liability. Some people may be concerned about financial liability, other issues, and just aligning on what we're really talking about when we're dealing with an incident is critical as well.
Yes.
Yeah, so true. It's that global mapping exercise, isn't it? So sort of understanding where those hotspots are. And really, I guess what you're touching on there, Jarno, is that multi-jurisdiction challenge, right? Like fundamentally, that patchwork quilt of different legal obligations and legal risks, right? I mean, tabletop is obviously one thing in terms of practice, but what effective strategies have you found, have worked in the past in terms of really drilling down as an organization to understand what those risks might be? How do you map that out in practice, especially given how frequently it changes?
Well, it's got to be a combination of designated individuals in charge of these issues across the organization, and we're seeing that increasing requirements of appointing a CISO in all kinds of organizations, but then also making sure that you're, as I mentioned earlier, about keeping track of local changes. We need to make sure that our local council, our local information security team keeps the headquarters updated about the developments on the ground in their countries, because we don't want to learn about those new developments and potential new risks when we have a live incident.
Yeah, which I suppose, Sean, relates to your point about communication, right? Just good communication and facilitating that.
Right. And in the incident response planning process, even before you get to say the cross-functional tabletop exercises, to think about that and how to identify the allocation responsibility to ensure the coordination and communication. And maybe it's an incident response commander or coordinator that is going to be identified at the outset, but his or her responsibilities are going to be to make sure that there are other incident commanders or coordinators into different jurisdictions that they relate to and communicate with immediately. So once they're aligned, then everything will go much more seamlessly. But it's critical to put that into the incident response plan itself. And then actually when you start to test it, they can get very familiar with one another. And then when you actually experience the incident, it's going to be a very fluid response.
And then it's also difficult to overemphasize the critical role of communications. And so we're making sure that, our organization, the elements of the organization at country level don't tell a different story to different regulators, and aligning on what's going to be communicated about an incident, because it gets unwieldy really quickly if we're telling a different story, or that even whether we're telling a story and what we're telling, and then so it's critical to coordinate that in advance as well. But prepare how we're aligning is rather, because obviously incidents have their own issues, and we can't really prepare in advance to communicate things that we're unaware of. But nonetheless, that you're aligning on how you communicate across the organization in various jurisdictions where you have varying reporting obligations to governmental authorities or individuals.
And I think one of the things we've learned, Jarno and James, especially in response to the encryption attacks in recent years, is that it's so important as part of your planning process to make sure you've got holding statements or templates ready to go for internal communication as well, especially on an international organization that's spread across multiple countries, is to make sure everybody's aligned with the fact that if you've got employees who can't log on for some reason, typically because you've got an operating system locked up, you're going to have to have a means of communicating with them relatively quickly to let them know that something's taking place, that you're investigating it, and that you're going to be providing them updates as soon as you can, so they don't start overwhelming the help desk or other information technology resources and causing other problems along the way. And then as part of that process, you'll also need to get ready to go with the third party holding statements far earlier than we'd ever want to. But with the encryption attacks, at some point you've got big clients, maybe they have access to your production systems for different reasons, or you've got client deliverables that are on a regular schedule, and you've got some serious penalties, say under various contracts. You want to make sure that you've got statements ready to go, and you've studied that and are prepared to navigate that when you have to. But you've got to be completely aligned there, because, like you say, in one jurisdiction you get ahead of yourself, and it could affect things in other locations as well.
Yeah, absolutely. I seem to find that there's something about that jurisdictional piece where, for global enterprises, where you have not competing business units, but business units perhaps with different priorities, and so inevitably there are different drivers and different desires to go to customers in that particular region first, and have that good news story, and potentially, to Jarno's point and to yours as well, Sean, you end up saying something that is not accurate or not entirely accurate, and that's when really the risk starts to materialize, right?
Mm-hmm. Yes.
So thinking perhaps just more broadly again as about coordination across those different jurisdictions. We're all at law firms that don't have offices in absolutely every country on the face of the earth, as I'm not sure anybody does. And so inevitably, we're working with a group or a network of local counsel. Can you guys just talk to the importance of that network and perhaps as well how you build it and how you go about finding folks who do a good job?
Go ahead, Sean.
Well, I was just going to say, similar to what we advise clients to do with regard to, say, go to a forensics firm and make sure they got a tri-party MSA in place before the incident. It's critical for law firms to have partnerships with other law firms and throughout the world. And it may be two, maybe three, maybe 4 days based on what your own internal firm's capabilities are. So that, and I think it's particularly important to have partnerships in places where it's a highly regulated jurisdiction. And we've got a couple countries in the EU, for instance, whether it be France or Germany, and to have firms that have actually relationships or really understand that regulatory climate, to partner with them and make sure you work very closely with them so your clients are well taken care of.
Yeah. And maintaining that list, not just having the list, but maintaining it, making sure that it's up to date. People change roles, they leave firms, they go in-house, you name it, but actively maintaining the list of contacts in various jurisdictions. And then in industries, certain industries, you have more obscure jurisdictions where there may not be any law that regulates, for example, cyber incidents, but you may still need counsel to confirm that there are no regulatory issues. So you got to have those more obscure jurisdictions without naming any country in specific, but making sure that you have a contact who can at least confirm or deny an issue is also vital. But active maintenance is key.
Absolutely. What's your guys' approach when you're thinking about which local counsel to contact? I mean, particularly in the early days of an incident where you understand that data from all over the world might be affected, but you're not entirely sure which, and you want to prioritize. And the first question is always, well, is there a privacy law in that country? Is it likely to be something under which we have notification obligations? What are you doing in terms of triage and figuring out, we definitely need to look at this area. We need to look at South Africa, or we need to look at China, or whatever it might be. I know there are high risk jurisdictions, but I'm just interested in your thoughts on, pulling together that list, and because you don't want to just send an email blast out to every local counsel, right?
Right. Right. How it's often a combination of keeping in touch, and the more the local councils stay in touch with you and do outreach, for example, on their jurisdiction, the more likely you are to get in touch with them when an actual incident materializes. So but then also obviously looking at rankings, and asking clients sometimes who they use locally. We might not be fully aware of all of their local contacts, but then also regional offices keep us up to date on some of these local council developments and their best friends. For example, in Asia Pacific, that's important. But again, so it is really a combination of all those things. But again, it comes down to that active maintenance, making sure that your firm, your clients know who to contact and who active, and making sure that these individuals are still in those roles, that we can rely on them.
I think this is one of those areas where experiential insight comes into play, where you may, I think to Jarno's point, you may have some folks that you've identified, maybe they're ranked well, they appear to have great reputations, but it's really a matter of interacting with them, perhaps during an incident, or maybe in a slightly different context, so you get a feel for what their true capacity is and their true responsiveness is. And some aren't necessarily what they appear to be in action. And so I think it's important to do that. And to the extent that you can exercise that more frequently, it becomes more reliable. But it's critical to, again, watch the changing of the roles and responsibilities and the positions, if you will, like keep your list up to date, like Jarno says. But at the same time, really pay attention to capacity and responsiveness would be, two key areas that I'd like to look at.
Yeah, I was going to raise responsiveness. I think it really is important, especially, incident response is all about being responsive.
Right.
what is the point then at which you're reaching out to local council? What is it? Just the mere mention of a particular country? Is it the mention of data affecting that country? What's the trigger?
It's a combination, but typically, once the initial forensics have been carried out, then we can start identifying jurisdictions that have been affected. Then we start reaching out to local council. But sometimes it must be a combination of not for the sort of the known unknowns and just start looking at which countries the client has operations in and start preparing for potential regulatory inquiries, even if we don't have a full knowledge of the details of the incident and which individuals or jurisdictions have been impacted. So it's got to be a combination of the two.
Right. And sometimes there may be so many countries affected that it's a matter of working with that outside counsel, that's your partner, to get a feel for what they perceive the priorities are. Because sometimes when you look at it, you may perceive that there are certain issues in certain countries based on our kind of almost an academic understanding of what that regulation looks like there. But you've got somebody else who's actually exercised that 3 or 4 times in the last couple of months, and they know that either it is a big issue or it's not. We need to treat it a certain way. And so it's a matter of having the list, like perhaps what we call maybe the state count domestically, but literally all the jurisdictions that are affected, and then walking through them and prioritizing them. And then when you prioritize them, then you'll develop your strategy in terms of what the notification timeframe may be, what the content needs to be, and to make sure we're completely aligned on how that's allocated.
Yeah, that's a great point. I mean, it's not the case, especially for global enterprises, that every country in which they operate is going to have the same set of risks or the same set of concerns, right? You're dealing with different data and you're dealing with different challenges. Maybe there's a company or at least a customer of that company's in one country, which is a real VIP versus other markets where they're perhaps not as focused.
Correct.
Yeah. And then from just a practical standpoint, it's also critical that you would have ironed out issues like conflicts and fees before an incident occurs. It's not really the time to start negotiating on those issues when the incident is live.
Yeah, those lawyers, they can be difficult to negotiate with.
I guess practically on that, Jarno, tell us how that's accomplished. That's just simply, dotting the I's, crossing the T's in advance, having some standard set of terms, but presumably these, you might not call on those for months, years, in certain occasions.
Well, I mean, there's certain awareness, in which jurisdictions your clients operate and may be impacted. So you kind of start to have those conversations in advance. And so you would have dotted your I's and crossed the T's before you have a live incident. Right? So it comes down to maintaining that list of contacts.
Preparation.
Yeah.
Okay. Let's shift gears then a little bit and talk about sanctions. Inevitably a huge topic, as ever. Just given the necessity of attribution, I think where sanctions is concerned in incident response, can you talk a little bit about how you're currently navigating sanctions risk, or what you're seeing, and particularly with respect to criminal issues? I know we mentioned already, for particular countries, you may well end up with individual liability, and sanctions is one such instance. But just given the variety of sanctions lists worldwide, again, it's one of those traps I feel that you can unwittingly walk into if you're not well prepared.
Yeah. So obviously, new threat actors emerge constantly, but once it's public what for example, the preferred term for a threat actor group is, it's helpful to run the name against sanctions list of countries in which the client operates. So that's one thing that you can do in advance of an incident, making sure that if the client is forced to pay ransom, that the client is not at the same time violating sanctions rules.
And I think it's critical to look at what the possible identifiers are. Sometimes the only identifier you have is a digital wallet ID.
Right.
And especially because of the different types of service that are sold now, whether it's ransomware as a service or some other type of affiliated service, it's sometimes difficult to really identify which group the franchise or franchisee, if you will, is a participant of. the code isn't necessarily the same, and that commonality analysis isn't going to necessarily help. IP addresses are obviously they're going to be masked, and that's not necessarily going to help. And so it's critical at the outset to be working with your forensics firm and making sure that they're looking for those commonalities as well, or those identifiers, so they know that's going to be a priority for the investigation if, in fact, those sanctions lists are going to be important moving forward.
Yep.
And are you guys working with sanctions specialists within your respective firms? I mean, what does this reach now in terms of its criticality to clients? I mean,
yeah, so it is a good reflection of how this area is evolving, because it's no longer just, us working with our cyber or data privacy security team. It's really cooperation between the international trade groups, white collar, you name it. But it's really become this kind of exercise where you need expertise from various areas, and not just cybersecurity and privacy teams any longer. It's the other groups, depending on jurisdictions and industries affected by the incident.
Right. In ferreting out the sanctions lists, we're typically going to be working with whether it's the forensics firm or a threat actor, negotiator, or communicator, and we're going to rely upon them to do the due diligence, and then we'll oversee that process. But there's certain guidance, of course, depending on which regulatory entity you're working with or checking through. But there are, I think, 47 different sanctions lists that we've got to be aware of, and making sure that we identify that, in fact, we've actually checked with them, and how we've checked with them, and the other identifiers we've used to draw our conclusions, so that you've got a defensible document once that due diligence process is completed.
Yeah.
And how, in terms of thinking about risk to global enterprises in particular, and boards, that defensible document that you mentioned, Sean, is that you're finding in your experience that's enough for you to get folks comfortable when they're thinking about their own individual liability, that they're not likely to suffer any particular blowback if they are paying ransoms? Or how exactly are you communicating that internally to these companies to get them comfortable that this is something that they can do?
Well, to the extent that there's a question that's going to call upon further analysis, but typically it's going to be readily identifiable. Most of the time, sometimes just from the digital wallet ID. Now, recognizing it's really a poor method to identify whether or not you're dealing with a sanctioned entity, because you really don't know. And very seldom do we actually know who we're dealing with. We're working with a digital wallet ID, which is the only thing that may appear or not appear in the sanctions list. But it's really a matter of working through all the available evidence. And I like to, if we need to, be somewhat creative and look at the circumstantial evidence, the historical evidence pertaining to bad actors, the behavior in reconnaissance, the behavior in the attack vector used, the different indicators of compromise that were used, and accumulate as much of the digital artifacts you can possibly imagine to ultimately arrive at the conclusion that they're not a restricted or sanctioned entity versus or they are. But if they're not, I think sometimes we become a little myopic and don't go as far as we can to actually identify all the digital artifacts that actually support that conclusion. And at some point, it's one of those things where you kind of know when enough is enough. And it's hard to say exactly when that is. But to the extent that you actually take your key identifiers and find that none of them appear in any of the sanctions list, and then in addition to that, you take your other digital artifacts, typically it's going to solve the problem, if you will, and ultimately help you formulate a good written conclusion.
Yep.
Yeah, it's I mean, you mentioned there, if they're not on sanctions lists, of course, but I don't know how recently you've had this, but in the event that they are on sanctions lists, that can be quite a challenge, I suppose. Can you guys talk around circumstances perhaps where you've experienced that, or are you yet to have that problem?
Jarno, I'll let you take the first step.
Well, obviously, it's a thorny, complex situation when you're dealing with the pressure of not having access to your data, and by paying, you would potentially get access to it again, and then you're identifying a trade actor that is a sanction list, and you violate sanctions laws. And without commenting on any specific client scenarios, it obviously is a risk assessment that where clients may come to different conclusions depending on what the potential liabilities are in any given jurisdiction where the company operates. So there's no one right answer.
I think the challenge is too. I think it's our job as the legal counselor, if you will, to provide them a sufficient analysis for them to know what they can and should do, right, what's lawful and what's not. And at some point, if we're ever put in a position where a client is perhaps not going to accept our recommendation, then we've got to make that decision about whether we can even move forward with that engagement. And it may cause us to, at some point, to say we've got to step out of it because we're going to see somebody, quite frankly, violate a certain law, and right, even against our recommendation, and that puts everybody in harm's way.
Yep.
Yeah, it's really well put. I appreciate it. It was a difficult question, but it's just nice to hear some of the more controversial elements discussed. So thank you. Just stepping away from sanctions, but relatedly to individual liability. So where you're dealing again with these global enterprises, and you have local laws where potentially you have individuals who might face sanctions or some right, kind of criminal liability in the event of any kind of breach or any breach of local law. I think that can cause issues, right, where you have individuals pushing back, perhaps in response to certain courses of action, making sure that they are informed as to what course of action you're even taking, whether you want to bring that person into the fold or not. Can you talk a little bit about what dynamics that creates and what difficulties that might bring?
Yeah, I mean, so one of the issues that's often forgotten, particularly by U.S. organizations, and that some jurisdictions negligently managing data could potentially be a basis for criminal liability. And just to illustrate this, for example, in the small country of Finland, there was a massive hacking of a online psychiatry service, and their CEO got a suspended sentence of 1 year for grossly negligent information security management. That is a section in their criminal code there. And I'm sure there are plenty of examples of similar statutes elsewhere. So it's kind of good to keep in mind that. But then also important to understand that if you're looking at when you're in an incident, you need to understand that your local teams might think of something completely different from what you are viewing as your liability here in your home country, right? So you can understand the dynamics and what's driving some of the decisions that are being made.
What it does, though, it really focuses on the critical importance of preparation. In any cybersecurity framework, it's going to start with preparation, and then, of course, at some point, detection, identification, ratification, etc. And then on the other side of the incident, you start to prepare again in the lessons learned or after action sessions, and you come back to preparation. And I think it's any business out there that is not in the process of preparing right now, they're static or they're getting behind. And it's critical as part of that incident response planning process to really think about your policies, your security controls, your contractual obligations, and do as much as you possibly can up front, because you can do it up front, and you should be doing it up front, so that you don't put yourself in or find yourself in a situation where you've got that liability, because that's preventable. And that's one of the things you should at the outset is kind of do that a gap analysis, maybe a liability assessment, and get a feel for what you need to change so you don't find yourself in that position.
Yeah, but specifically just during live incidents, where you have situations where perhaps individual liability might be a problem, are you bringing those individuals into the decision-making process? Are you seeing them involved, or does it tend to be still maintained by the central incident response team, and maybe those individuals who might face that liability are just expected to accept it as part of the risk of doing their job?
I think it depends on the role and responsibility, but typically, if we're dealing with executives, my position is they should be part of that conversation, obviously, so they're apprised of what's taking place. And oftentimes, the non-InfoSec or IT individual may actually have a common sense solution to whatever the problem might be. And sometimes it actually may involve some proactive work, whether it's with a regulatory entity or someone else that may have an iron in the fire. And of course, it's a double-edged sword too. You got to be very careful there. But there are a number of different options there, and I think it is helpful to bring. If I'm put in a place where I'm facing liability, I would certainly like to know about that. So maybe I could be part of the solution.
Right, but then also we must remember that sort of the examples of criminal liability are still somewhat rare, and by doing sort of basic things right, having your staff trained on information security, having an incident response plan that's being tested, having appropriate software updates, making sure that your network security is up to date, all of those elements, make it very much more unlikely for any individual to be facing personal liability for some of these incidents.
Yeah, it's tough though, right? Like it's a tough conversation to have to persuade somebody who, even in the slightest risk of something like that, you're still going to have some concerns.
Right.
Yeah, I find that quite a challenge. And then thinking about maybe the forward-looking piece just for a moment, and some of the actions that we're seeing, particularly in the US, to prosecute CISOs and perhaps other executives. What are your thoughts around that, and just in terms of direction of travel, and really what's driving it?
Can't comment on a specific case, but generally, obviously, it is challenging to identify individuals who want to be named CISOs, if that potentially means personal liability. If your organization is involved in an incident, particularly in an environment where increasing regulation around requirements to appoint a CISO. So you're starting to fish in a very small pond of a pool of talent, if you will, because, the sort of fear of potentially being held liable if the organization is not appropriate in managing information security. So there are those considerations that are very much present.
It's something that seems a little odd, but when you think about the fact that you've got a CISO who wants to make sure that what they're doing, whether it's their own behavior, their policies, their procedures, probably should be subject to third-party audit just to make sure they've got a third party that can be their expert witness or something like that happen. The trouble is then you start to introduce extra third-party vendors to your system. And what we've seen, the majority of our incidents really seem to emanate from third-party vendors who are hacked. And you look at the secure transfer file protocol issues in the last 24 months or so, where it's obviously a secure file transfer protocol that's recommended to be used. It appears to be a legitimate product, and then you've got thousands of corporations affected because they're relying upon that. It's a third-party vendor, and then they find themselves in litigation. But it's that sort of thing too. Even the most secure applications, ostensibly secure applications, how do you vet that? How do you challenge that? And what liability do you face for that? So it's a very complex scenario, and I think it's probably going to involve a few more third parties to serve that kind of an auditing function to cover somebody, if you will, along the lines. But we've also got to be careful and make sure that we're vetting the auditor as much as any other vendor in the process. Yeah,
absolutely.
Speaking of auditors, I don't know to what extent you guys are seeing, particularly during reporting phases of companies, auditors perhaps pressing more for information regarding incidents, especially when perhaps there's a live incident ongoing when they're on site. I've certainly had that happen to me. Are you guys seeing more detailed requests from auditors, particularly where there's perhaps evidence that a TA has had some interaction with financial systems or anything similar? And if so, how are you dealing with that?
Absolutely seeing more requests from auditors relating to information security generally, and obviously with the SEC reporting requirements shortly online, it just has to be an element. But then there's more scrutiny from auditors, more questions to the in-house team around information security generally. But whether then that results in an actual improvement in information security practices of listed companies, I'm not quite sure yet.
Right. Yeah, it seemed to me that there was an element of proving the negative during this particular matter that I was involved in, where you're expected to demonstrate to auditors that nothing has been changed on these particular systems, which of course forensically is perhaps achievable, but it obviously diverts resource away from the investigation itself. I'd just be interested in any thoughts you had as to how you balance that.
Well, the challenge is you've got to at least attempt to comply in some respect and allocate resources to answer the questions. But what I too have found that it can result in a tremendous consumption of time, energy, and cost, especially if you're sometimes conducting an additional forensics investigation and starting to consume some of their internal IT and InfoSec resources allocated to that work with an outside vendor, ultimately to prove the negative. And maybe you've you're contacted by maybe an intelligence agency or a law enforcement agency in a certain sector, and they see somebody quote unquote beaconing out of a system, but in fact it turns out it's not what it appears to be, and somebody never even got to the firewall. But you nonetheless spent $100,000 trying to investigate that and prove the negative, and it's challenging. I think we're going to see an increased amount of time and effort put into that, I think. And then at the same time, you also have, after the incident becomes public, and it's not necessarily after like a state regulatory authority or another, some form of jurisdictional authority is actually informed of it officially, but they hear about it. Then that sort of proactive inquiry is difficult as well, because once again, you don't necessarily know all the facts yet, and it's very difficult to make sure that you're reporting accurately if required to do so, and not overstating what you have or possibly understating it just because you don't have all the evidence yet. So I think you've got to be very, very careful with the language you use to make sure everything you do say is accurate at that time, and you can show that.
Yeah, just the perennial tension really between wanting to say something positive, but not going too soon. And it's sort of a similar tension between the evolving threat landscape and the way in which regulation is rushing to catch up. And Jarno, you mentioned the SEC rules and how are you seeing those play out, and particularly, I suppose, with respect to global companies, some of which might be, of course, based in my part of the world, where they might be foreign private issuers, for example, and so there are differences and distinctions between those rules. But just interested in your 2-minute take on what's going on.
Well, it really comes down to what we talked about earlier, which is consistency and communication aligning on what we're going to state, because obviously the SEC rules require a materiality assessment, which may not be relevant in some of those jurisdictions. Elsewhere, for example, the GDPR-related personal data breach notification thresholds are very low. And similarly, U.S. state law level thresholds for notifying incidents might be very different from what you consider a material incident for purpose of SEC reporting. So it's a complex assessment, but it really comes down to aligning how we're going to communicate, how we're going to coordinate communications related to an incident, so that we tell essentially the same story consistently. But then obviously there are industry-specific financial services organizations have their own reporting obligations. Energy companies may have their own reporting obligations, depending on, for example, the jurisdictions in which they operate. And so it is really a complicated web of communication issues, and aligning on those in advance is critical.
And I think this falls into an area where when we see a more mature regulatory entity, an entity that's been involved in regulating to some extent information security for some time, they tend to have a much more reasonable approach when it comes to data security incidents, and they focus more on the remediation, not the fact that it happened or how it happened. Whereas my perception is that, and my experience is that, the SEC's on the nascent side of that. And as a consequence, we're going to see some tension there. We're probably going to see more litigation there. And over time, hopefully they'll have the personnel that actually do have more experience in information security, understand the complexities, can actually see the nuances there that are really relevant in terms of whether it's a materiality, ultimately the threshold decision, conclusion, but they really understand too that the entity did follow commercially available best practices at the time, as opposed to trying to find fault.
Right.
And I think
Yeah,
when that regulatory entity, whether it's the SEC or another, really focus on the remediation, the due diligence the organization engaged in after the knowledge of the incident, they're going to show that they took it seriously. And now the information is more secure than it's ever been before. The message has been received. There's no reason for additional regulatory scrutiny. And Mr. Corton, you're here.
I am back. Well, hey, thank you so much, Sean, Jarno, and James. Great job moderating. That's a wrap for this session. Our next and final panel is up in 5 minutes. It's going to be a deep dive into some technical techniques and tactics that are being used today. Join us again in 5 minutes. Thank you.